Welcome everyone again to today's webinar for the New American Task Force. Today's topic is preparing your business for immigration policy changes under the new administration. This is a topic that I think is very prompt and very relevant for a discussion. So we're so glad to be able to provide this resource to you today. My name is Zeman Sao, and I am the President and CEO of the Center for Economic Opportunity and Belonging. I'm here as part of the New American Task Force. The New American Task Force is a co-convened by the Center for Economic Opportunity and Belonging and the Governor's Office of Economic Opportunity and the Utah Center for Global Talent. The New American Task Force, it consists of over 150 stakeholders across the state with the primary objective to make sure that we are preparing new Americans to contribute to the economic success of the state of Utah. Next slide, please. Just a quick overview of the agenda for today. Following my remarks, I will pass the torch to a great partner at the Governor's Office, P. Cadella, who will be providing some welcoming remarks. Follow that, we'll have a community announcement, and then we'll move on to a presentation. Following the presentation, we'll have an open dialogue. Just a reminder that this is a webinar, and in order to ask the questions, you must type in the questions in the question and answer section of the Zoom feature. So please do not type your questions on the chat. Make sure you use the question and answer session. Following the presentations, we'll also hear from Liliana and Bailey, who will be sharing some community resources, and we'll end with closing remarks. I'll turn it over to you, Pete.
Thank you, Z. Appreciate it so much. Appreciate our partnership with the Center for Economic Opportunity and Belonging. As Dee said, I'm a managing director in the Governor's Office of Economic Opportunity. You may know that in 2021, the Utah legislature created what we now call our Center for Global Talent. And our goal is to connect Utah business with workforce. And we know we're in a space that is important. Utah has low unemployment. We need to provide economic opportunities to so many. So just want to welcome you, thank you for being here, and acknowledge that we do live in times that experience that none of us have been through yet, and we're all in this together, and hopefully we'll provide some good resources and connections through this webinar that will help. And please don't hesitate to reach out to our center. I'll turn it over to Claudia. Thank you.
Good afternoon, everyone. My name is Claudia Gutierrez Sanchez, and I'm serving as the interim director for the Utah Center for Global Talent. Wanted to present a few community announcements today before we get started with our topic. So we have the Utah Citizenship Initiative website, which we have a QR code, and we can put the link in the chat as well for you all to share with residents and organizations and local governments and residents of Utah here, where we have this website as a hub set to help promote the benefits of naturalization, to provide resources and tools to naturalize, and then also connect different Utah residents and businesses with their local citizenship preparation and workshops. So I encourage you all to, if you have employees or you work with new Americans, I encourage you to visit the site to help guide them through citizenship resources and tools. Next slide, please. Another community announcement we have is next Thursday, and then the week following that, we'll host a webinar. But next Thursday, we have an in-person event that the Division of Professional Licensing, the Utah Center for Global Talent, UVU, and Centro Hispano are hosting. It's a Get Licensed Step Ahead Journeyman Electrician in-person information session where the Division of Professional Licensing will be going through the licensing steps for a journeyman electrician, specifically for those who are internationally trained electricians looking to get licensed in return and contribute to the workforce here in Utah. So that will be an in-person event at UVU next Thursday. That one will be held in Spanish, and then there'll be an online webinar in English with the same information the week following on February 20th. Again, we have a QR code there if you want to scan to register for this event, or if you want to share this with communities you work with. And we'll also put the link in the chat. Next slide, please. The last community announcement we have is the Mill at Salt Lake Community College is hosting a global business management program. This program is great for business executives, professionals, working staff, and entrepreneurs who are interested in global business practices. If you have further questions, they have an online information session on February 26th at 5:30. You can use a QR code to sign up for this free info session to learn more about this program, or you can contact Vanita Ross at 801-957-5336 or her email that's listed on the screen there. So that's all the community announcements we have today. So I'm going to turn it back over to Z to introduce our presenter.
Thank you so much, Claudia, for those community announcements. It's my pleasure to introduce today's speaker who will be sharing with us really important information in helping us to be prepared and be in compliance with the changes in the new administration. Kathleen Weron has extensive experience in this field, and I'm so glad that she said yes when I call her and tell her that this is something that the community is needing. She is an attorney and partner at Ogletree Deakins. I'm not going to read her entire bio because it's pretty long, but she has over 30 years of experience representing employees in both federal and state court before various departments throughout the Department of Justice and so forth. And so she's well equipped to do the presentation today. And without further ado, I'm going to turn the time to Kathleen.
Okay, next slide, please. Well, thank you, Z. I want to thank everyone participating today. Before we got started, I told Z that I've had to update this presentation a few times, and it's only been 3 weeks in the new administration. So one of the things I want to make sure is clear is that this will be an ongoing topic and developing over the next not only months, but years. So we may be doing another update, but I'm here today to get you up to speed on some of the new policies, what to expect under the new administration. And one of the things that I did and my law firm has done in preparation for this webinar is really address 2 main concerns that we know employers have right now. One is their concern for the disruption of business, as well as knowing what to expect if law enforcement or ICE show up to conduct an audit or investigation or do an enforcement action at your workplace, what you can and cannot do, what is the best practices for you as a business to comply and also not obstruct. So we really wanted to address those concerns for you today, and certainly welcome questions that hopefully we'll have a chance to address at the end of this presentation. Next slide. Next slide. So we have heard a lot of headlines and news reports, and certainly the administration has been transparent about the fact that it is going to increase immigration enforcement actions within the first several weeks of the administration. And these enforcement actions may be taken against individuals who are in the United States without proper documentation or have violated orders of removal. A quick reminder here, in the previous Trump administration, the focus of immigration actions during 2017 to 2020 really was on audits and I-9 audits. That's where we saw the most action from the previous Trump administration. We anticipate that that will continue, as well as confirmation from the Trump administration that they're going to increase immigration enforcement actions. The priorities of ICE and the Trump administration is really to focus on 4 main categories. And I think this is important to know as we proceed. We're hearing a lot of news reports, but the focus of the administration, at least right now, is on focusing on organized crime, human trafficking, specific criminal convictions, and unauthorized entry or failure to depart after removal orders. So that's the focus right now, as opposed to just ICE raids on a workforce. Now, again, as I cautioned at the beginning of this webinar, that things may change, but that is the priority of the administration currently. And it's been reported, though it's not official, that quotas are between 1,200 and 1,800 arrests a day. And although this is not official, the Trump administration has certainly signaled that it's concerned about moving quickly, especially with regard to the categories I just mentioned. There is an official dashboard to report on numbers, and so we'll be monitoring that, but that is the expectation currently. Next slide. What has also changed in the new administration is that the Department of Homeland Security has expanded the locations at which enforcement actions occur. These areas were previously designated sensitive areas, but ICE is now authorized to conduct enforcement actions at schools, medical facilities, places of worship, social establishments, children's gathering places, places for disaster or emergency response, wedding or funeral sites, or public demonstrations. So in addition to the workplace, these are also areas that previously were designated sensitive areas, but now are areas where enforcement actions may occur. Next. All right, so I think there is a lot of, certainly a lot of media attention is being given to this. There's a lot of anxiety regarding, what should employers do, what should they anticipate, and what should they do in the event that there is an ICE enforcement action at your workplace. We're going to cover all of that, but here's what you should do now. And that is make sure your Form I-9 practice is best practices. The Immigration Reform and Control Act requires employers to verify all job candidates, which means they have to fill out the Form I-9. I'm sure most of you are familiar with this practice, but it is a good time now to revisit how you're storing that information and completing that information, and possibly do your own internal audit in the event that you are audited by ICE in the next while. Next. So there's a couple of important implications here. First, employers cannot overlook discrepancies between a job candidate's I-9 disclosures and immigration documents. This is a highly sensitive area because you must follow the I-9 form. You're limited to what you can ask for, and you're limited in questioning an employee who presents I-9 documents because you could run afoul of Title VII discrimination laws. So it's a tightrope that employers have had to walk for a long time. But as you're doing an audit, keep in mind that while you can't accept questionable immigration documents, you also have to be careful that you're not running afoul of Title VII's discrimination laws and discriminating against an employee who has presented you with documents that appear reasonably valid. We'll talk about that in the next slide. So as you're looking through your practices and doing your own internal audit, which I highly recommend you do now, and make sure that no later than the first day of employment, but not before accepting a job offer, an employee has completed and signed the I-9 form. When you're doing the audit, make sure the boxes are checked, the form is signed. Then you, as the employer or your HR department, whoever is in charge of handling your I-9s, must complete and sign the Form I-9 within 3 business days of the employee's first day of employment. Then you must also physically examine consistent with the procedure authorized by the Department of Homeland Security the documents that are listed on the Form I-9. Next slide. So the Form I-9 contains this information in List A, and employees may present one form of documentation from List A or a combination from List B and List C. Make sure that you're complying with that List A and that you have requested and the employee has presented the right combination of documents. Make sure to also check the expiration on any documents that are presented. And next slide. And here's an example of that. It's worth revisiting if you're doing an internal audit and you're with the Human Resources Department on this call. Go back and look at your I-9 forms. Make sure you're complying with the list of acceptable documents. If you're auditing your own HR department, pull the I-9 form and make sure you go through this with your HR department so that they are in compliance. Next slide. And again, as I cautioned, you're required under the law to accept facially valid documents without further inquiry. So if the photo matches, if it doesn't look like, the name has been whited out and typed over, and, they're consistent with the documents that they've presented, then you are not allowed to do further inquiry. You do have a duty to inquire further under what the government calls constructive knowledge standards. And we'll talk a little bit about what might trigger you to question further. But again, this is the tightrope that you have to walk. If the documents appear facially valid, they're not expired, then you cannot inquire further. If you terminate the employee or inquire further or engage in maybe requesting further documents, this could implicate discrimination concerns under Title VII. So for sure it's a tightrope, but you have to walk it. So let's just quickly talk about what these constructive knowledge standards are when you're doing your internal audit and speaking with the people in your organizations who handle the I-9s. Next. First of all, you're not a document expert. You're not required to be a document expert. This is an exercise of common sense and good judgment. So carefully review the documents, ensure they appear, and the standard is reasonably appear to be genuine. Like I said, they're free from typos. They're not obviously altered where, something looks like it's whited out and typed in or cut and pasted. Ensure that the documents reasonably relate to the person presenting them in age, in appearance, name. Check the document's expiration date. And then if you're unsure at that point, make a clear copy and have either an immigration attorney review the document, or if you haven't signed up for E-Verify, E-Verify can be helpful for you in these situations. Next slide. Just a quick note on E-Verify. The federal program is voluntary, so it allows you to submit information from employees' I-9 forms to the U.S. government for confirmation that the employee is work authorized. Entirely voluntary. Utah has a statute that provides that a private employer who employs 150 or more employees after May 4th, 2022 may not hire an employee unless the employer is registered with and uses a status verification system such as E-Verify to verify the federal legal working status of any new employee. I've included the website here. You can find it easily in your search engine just by entering Utah E-Verify. So in Utah, E-Verify is required. Now, little caveat about Utah's E-Verify statute. It's entirely based on the honor system. So if you are an employer who isn't using E-Verify in Utah and you have 150 or more employees, do not panic. There are no penalties if you do not use E-Verify. You can't be fined, you can't be cited. It's really just an honor system, and the website has a list of employers who use E-Verify. But given if you have questionable documents, or you're in a position where you're not sure what to do when presented with questionable documents, a quick and easy solution is to use either the federal or Utah E-Verify system. So that's really a tip to help you with that process. When you're doing your internal audits, you may want to sign up for that. Slide. So highly recommend that right now you either do the internal audit or you meet with the folks in your organization who are doing the internal audit, or who are handling I-9 forms, and do an internal audit with them to make sure that you are following best practices, you're in compliance, and in the event that you do receive a subpoena for documents from ICE or even the state, that you'll be ready to produce these documents and comply. Next slide. So a few tips here. And one, track re-verifications and temporary visas that will expire. Develop robust employment verification policies that integrate state and federal E-Verify requirements. Establish protocols for addressing Social Security number mismatches. And again, in that case, I would recommend you either contact an immigration attorney who can help you, or simply use one of the E-Verify services that are available to you. And develop escalation standards of practice for fraudulent documents or document concerns. And then reinforce the importance with the people in your administration or the department in your administration handling I-9s of avoiding discrimination while adhering to federal and state laws. Next slide. Another concern that I would make sure in my internal audit, that if you use staffing companies, PEOs, or have vendors who supply contractors, now is a good time to pull out those contracts. If you don't have the contract on file, get it, and review the language. Make sure that the staffing company, the PEO, the vendors have reasonable representations and warranties in place. Somewhere in the contract, the staffing agency or the PEO or the vendor should indicate that they have adopted best practices and are fully compliant with the I-9 laws and any other relevant immigration laws, to ensure that the temporary employee, the vendor, etc., is legally authorized to work in the United States. Next slide. Okay, so I wanted to cover that practice because it is a good time, and it really is the foremost priority that you should have right now is revisiting your I-9 practice and do your own internal audit to make sure that you would pass an audit should you be served with a subpoena. So I wanted to talk a little bit about the ways now in which ICE can show up at your workplace and for what purposes. The first would be a visa sponsorship verification. This has typically been ongoing in the Obama administration, the first Trump administration. There were less audits, less visits during the Biden administration, but we can expect additional unannounced visits to check on visa sponsorship verification. These visits do not require a subpoena or a warrant. Usually you might just receive 1 or 2 ICE agents at your door who want to ensure that you're in compliance with employer-sponsored visa programs. And these are really not that unusual, and they're really not that heady. They will usually request, for example, to speak. You might have an employee who is working for you on an H-1B visa. And what they're going to want to do is just have a conversation with that employee, find out what they're doing, confirm that it's what the employer said that they would be doing. And typically, in an unannounced visit, they will ask to speak to that employee. You can let the employee know and set them up in a conference room. I think the best recommendation that I would offer is, in that event, I would simply say, I'm happy to, coordinate with our employee and you and set up an appointment at a mutually convenient time. And then they'll come back at that time. The employee can meet with them in a conference room and discuss whether or not they're in compliance with your employer-sponsored visa program. This is the least stressful and the least one of the possible visits you may receive from ICE to get worried about. The other ones we'll discuss in the next slide. As I said earlier, the Trump administration was the first Trump administration was really focused on showing up at a workplace and doing a Form I-9 audit. And in this case, what may happen is an immigration agent may visit, request the employer produce Form I-9 documents and supporting documents. Usually the agent, or there's maybe 2 or 3 agents, will deliver a written request for documents in conjunction with a subpoena. You have 3 days to respond to that. So typically what this looks like, they show up, they serve the subpoena, the request for documents is usually attached to the subpoena, asking for maybe your I-9 forms, your photocopies of forms that you requested, and they should leave. You do have 3 days to respond. That's typically a hard deadline and not negotiable, but it is a situation where you'll be served with a subpoena and then the ICE agents should leave. You're not required to immediately provide that information. Agents are not permitted to ask questions or search the premises, and they must leave after delivering the request. They have no right to go look at those documents, photocopy them for themselves, or take them. That is something that you will have 3 days to gather the documents. If you've done your internal audit to ensure that everything's in place and I-9 forms are filed separately from personnel forms and are ready to be produced, typically 3 days will give you time to produce the documents requested in the subpoena and document request. Next. Now, this is where there's a lot of anxiety, and that's where an immigration agent may present an arrest warrant or a search warrant. So in a lot of these situations, when they have a warrant, you can expect a lot of agents to be on your premises, which of course can be very disruptive, very anxiety producing. And a judicial warrant is going to be signed by the judge, and it is the only type of document that would authorize government agents to enter private areas of a business. It must specifically describe the areas that may be assessed and also the time period for doing it. And we're going to talk about the different warrants that could possibly be served on you, and I'm going to offer you sort of a plan on what to do in the event that that happens. Next slide. So, as I said, ICE agents may arrive at a work site without prior notice. These are knock-and-enter warrants. ICE agents are not police officers, but their uniforms may display police or federal agent or ICE. They may be armed. Occasionally, local police officers may accompany ICE agents during these actions, and they may visit your business to locate a specific individual or individuals. And during their visit, they may attempt to question, detain, or arrest other individuals present. Next slide. So given that we could have ICE show up to do an audit on your employer-sponsored visa programs, and you could have ICE show up with a subpoena and a document request for your I-9 documents, or they could show up with an enforcement action. Importantly, you need to be prepared for all three of those scenarios. Next slide. First thing you're going to want to do is develop a written response plan in advance. Can you advance? I think there's some bullet points on this slide. First thing that you are going to want to do, and usually this is providing some information and training to your front-facing employees. If you're in an office, that would be your receptionist, anybody who would welcome the public into your office building. If you're in manufacturing, think about who that first point of contact may be that ICE would have with your business. And you need to provide information and training to that person regarding what they should do in the event of an ICE enforcement action or an ICE visit for any reason. The first thing that this person needs to be advised is who are the company's designated points of contact. So if it's the receptionist in an office building and 50 ICE agents, possibly armed, show up in your office building, that is going to be an enormously intimidating and frightening experience for this person. Who do you want this person to immediately contact? I would recommend it's somebody in high in management, and if you have in-house counsel, in-house counsel. Now that person should right now, as soon as this webinar is over, know who those people are and have their contact information and how to get a hold of them immediately in that situation. Secondly, that first public-facing point person, whether it's manufacturing, out in the field, or in an office building, can request and should request identification and contact information of the government agents or the point person who is appearing in your workplace. That would include, that's their credentials. They probably have a badge and will present it. That's what they should ask for. They should know the name, the phone number, the email, the business card, and the badge number of that person. So ICE shows up, they say, we have a warrant, we want to search the premises. That person knows immediately, just a minute, let me notify the proper people, immediately notifies the people, then turns around, who is, like I said, your designated points of contact. Somebody in management and or in-house counsel, or both, and then turns back and asks calmly for, may I have your credentials? And if they haven't presented a search warrant, that person needs to be trained to ask whether or not, are you here today with a search warrant? And if they have a search warrant, they need to present it. If the agent does not have a search warrant, their access is limited only to public areas. So that would be probably the lobby or the reception area, maybe an adjacent conference room if the door is open, the lights are on, and they should not try and get into private areas at all without a warrant. So if you have an adjacent conference room and it would be less disruptive, you can instruct that first point of contact employee, after you have notified the points of contact, requested credentials, confirmed whether or not there is a search warrant. If there is no search warrant, just escort them to our adjacent conference room and tell them somebody will be right with them, or please have a seat, somebody will be right with you. And that should be the end of the conversation. The agent should not be given any access to inspect the facility or work site or be allowed to interview employees until the points of contact show up and there's a discussion that is had. And that's the case if there is no search warrant. Point here as well, in those public spaces, you know, your reception area, your lobby, your welcoming area, any employee who wanders into that public space while ICE is there can be questioned because it's a public space. So, you don't have to send the alarm, hey, we're on lockdown, nobody come up here, but be aware that those public spaces are accessible to ICE agents even when they do not have a warrant. Next slide. If they do show up with a warrant, really it's the same process. Immediately, your point of contact person, that first public facing person, should notify the points of contact, the person in management who you've already designated as the point of contact and or in-house counsel. Ask for their credentials, ask whether they have a search warrant, and then politely ask them to please wait until they can meet with your company's point of contacts. If they have a search warrant, they may not. If they don't have a search warrant, they will have to stay in a public area. Importantly, you don't have to consent to the search. So if you do consent to the search, or you're that first point of contact or anybody in the organization says, oh, sure, come on in, let me show you around, or make yourself at home and go ahead and walk around, you've consented. Now it doesn't matter whether they have a search warrant or not. You've consented to them being able to search the entire premises. So if they do have a search warrant or they don't have a search warrant, be careful with what you consent to. If they have a search warrant, you're limited to the time and place and spaces specifically identified in that search warrant. If they don't have a search warrant, they're limited to only your public areas. That if I came into your facility walking off the street, the door's not locked, I could walk right in, so can they. But if you have areas that are locked, you have areas marked that are as private, without a warrant, they can't access it. Be careful that that first point contact person doesn't just consent to an entire search of the area. Agents may demand that equipment be shut down and that no one leave the premises without permission if they have a warrant. And agents may move employees into a contained area for questioning if they have a warrant. Next slide. So you've heard me talk about public and private areas. This is important for you right now. Think about your facility, your office, your manufacturing floor, all of your operations and what they look like in terms of how they are housed. Private areas are doors that are locked, areas where private signs are posted. They're areas that are accessible to anyone without permission. In other words, if I'm walking by your office building, can I even get to your floor? And if I do I have to meet with the receptionist in the lobby area? Or how would somebody just walking in off the street be able to access your areas? If it's public and open, ICE can access those areas even without a warrant. So that would be areas like your reception area, your lobby area, dining areas, parking lots, waiting areas, anything that can be easily accessed by somebody without permission. Private areas, again, those are doors that are locked. You have to use a key card to get in, or there are private signs that are posted. So one of the things in evaluating your workspaces that you can do right now is evaluate and assess what areas are private and If they're not locked or require card key entry, consider posting private area signs that are visible to the public. And then you would be able to enforce those areas in the event that ICE comes to your workplace without a warrant, because it's posted clearly, this is private. Next slide. We talked about public areas. Next slide. Oh, go back to private areas just really quickly. Again, consider what is private in your business. If it's not locked, close the door, put a sign on the door that says private, and then ensure that you're enforcing that policy, not just with ICE, but anybody who shows up. So visitors in the public cannot enter these areas that we have marked as private. And make sure your employees, especially that first public-facing employee who might be the first one to encounter ICE and agents, that you are not to grant permission for anyone to enter these private areas. Make sure you've contacted your points of contact before granting ICE or anyone else, enforce it indiscriminately, private areas. Can you go back to the slide on private areas? I think there's a few more points there. Oh, okay. Next slide then. Okay. All right, so why is this important? For private areas, ICE must have a judicial warrant to enter that area unless you consent. And you're going to advise your receptionist, that first point of contact, do not consent. And you don't have authority to consent. That is somebody, that is something that only the points of contact, which we've previously designated, can do. But importantly, without a warrant, ICE cannot enter those private areas. Next slide. All right. Now, assuming that ICE does show up with a judicial warrant, what do you want to look for? First thing you want to look for is it has to be signed by a judge. And it must indicate either a United States District Court or a state court at the top of the warrant. So it's issued by a court, either federal court or state court, and it has to be signed. An unsigned warrant is not enforceable. If ICE agents attempt to enter a private area, the employee, that first point of contact, or even the key contacts in the organization that you've previously designated, should say, this is a private area. You cannot enter without a judicial warrant signed by a judge. Do you have a judicial warrant? And you request to see that warrant and review it. And again, what you're looking for is it's issued by a judge, or it's issued by a federal or state court, and it's signed by a judge. Next slide. This is an example of what a warrant would look like. At the top, you can see it's issued by the United States District Court for the Eastern District of California. It indicates who the parties are. It indicates that it's a search and seizure warrant. It will have the date. This has one date, May 9, 2011. That's the date that the warrant can be issued. And it's a little bit small. I'm not sure if you can see it on the slide, but it will have either an attachment that says what can be accessed. If ICE is there to arrest a particular specified individual by name, it should have that individual's name on there. And then at the bottom, you're going to make sure that it's signed by a judge. Next slide. And I want to distinguish a judicial warrant from an administrative warrant because we have seen this. So an administrative warrant is issued by the Department of Homeland Security. And you'll usually see a label or a heading or a seal that says DHS or Department of Homeland Security. and it will usually contain the actual form number. What we've seen is DHS form I-200, warrant for arrest for a particular individual, or form I-205, warrant for removal or deportation. This administrative warrant does not permit ICE agents to enter your private areas without your consent and permission. So if you are presented with an administrative warrant, you may refuse to comply with the warrant and ask the agents to leave. And again, this is not something that I would have the point of contact person, the first person who interfaces with the public, make that determination. They can certainly request if there's a warrant, but the point of contact, which is either going to be, you know, somebody in high management or your in-house counsel, should be trained to know the difference between a judicial warrant, which is issued by a court, either federal or state, signed by a judge, and specifies the purpose of the search, the date, the time, the place, and or whether it's an administrative warrant. So again, if it's only an administrative warrant, you do not have to comply, and you can ask the agents to leave. Now, what may happen is the agents then go and get a judicial warrant and then execute a judicial warrant. But in any event, you should know that an administrative warrant, which doesn't require all the steps, it's much easier for the Department of Homeland Security to issue this kind of a warrant and give it to the agents and then have the agents show up at your workplace, than it is to go through the process of going to a judge and presenting probable cause and getting the judge to issue a warrant. So this is the easy button for the Department of Homeland Security, and you may see agents show up just with an administrative warrant. So it's important that you know that you may refuse to comply and ask the agents to leave if they're showing up with an administrative warrant. Next page. This is an example. I've marked it sample. They may change, but this is what an administrative warrant would look like. As you can see, it has some of the hallmarks of administrative warrant because it's issued by the U.S. Department of Homeland Security. It is the arrest of an alien. It looks official, but again, it is not a judicial warrant, has not been issued by a court, has not been signed by a judge, and you do not have to comply. You know, I've said this before, if ICE agents claim to have a warrant, you can see why now it's important to request a copy and review it, because you're going to be looking to see if this is a judicial warrant or if this is an administrative warrant. And if they don't have a warrant, you can allow them in your public spaces, but they're not allowed in your private spaces. Again, that first point of contact, the receptionist, the public-facing employee should immediately send a copy to the designated points of contact, and that person or those persons should be trained on what to look for and know what they have to do depending on the nature of the warrant. Again, another important point here is when you're looking at the warrant, make sure that the period of validity has not expired. Sometimes judicial warrants will say, you may search this area on Monday, February 10th from 2 to 5 p.m. And if ICE shows up with a judicial warrant at 5:30 p.m., that's not valid. Or if they show up on another date, that's not valid. So you're going to want to check the period of validity on the judicial warrant. The other thing that you want to check is the address that's listed on the warrant, because this has to be specific. If the warrant says we're going to search your facility at 3250 West, 1900 South, and the warrant doesn't have that address exactly, then it's not enforceable on the site that they showed up if the address is different. If it's an office and it says we are going to search this office building, suite 950, and you're in suite 900, it's not valid. So you'll want to check the period of time, date and time. You're going to also want to check the address. Is this warrant applicable to the exact site that you've shown up at. And then sometimes there will be a description of the items to be searched, or possibly the individual or individuals to be arrested. Next slide. Oh, I think you missed, yeah. Again, if agents show up with an administrative warrant, you may choose to decline further cooperation. Again, what's very likely to happen is that we're going to see them again, except with a judicial warrant, but that is your right. And then if the administrative warrant actually names one of your employees, you are not obligated in response to that to disclose whether that employee is present, and you're not required to lead agents to the named employee. Next slide. All right, so assuming that ICE has shown up, they have a judicial warrant, it's issued by a court, either state or federal, it's signed by a judge, they've got the date and time right, and they've got the place right, and they're going to execute on that warrant. One of the things that you should prepare your workforce for is that in that event, there may be numerous agents. They may be armed, and it may be quite frightening. We've had situations where enforcement actions have occurred in workplaces with 1,000 ICE agents. So that's going to be very intimidating. It is important to let your employees know, especially the front contact person, to remain calm. And easier said than done, but the more that you can proactively have these conversations and proactively plan and train your employees, the more likely it is in these situations, which, you know, can be very frightening, very anxiety producing, and certainly situations where employees may never have been in these kinds of situations. We've got our plan, we know what we're going to do, and you're supposed to follow these instructions. This is your role. And most importantly, everybody remain calm. If the government enters private areas with or without a warrant, you can have employees follow each agent. I would recommend that, you know, you have a designated employee who just follows them, takes notes. You can absolutely take notes, write down individuals that they talk to, write down anything that they may confiscate, computers, personal devices, files. You're going to want to document that. And you can also record. It's totally legal. Somebody should be that designated person to follow ICE, take notes, and maybe have another person who's just video recording everything. And observe the agents to ensure they're complying with the warrant's terms, that they're not going into spaces that are beyond what was allowed in the warrant. You certainly do not want to obstruct, block, or interfere with their activities. And, you know, by no means allow news reporters to have access to the work site. A couple of notes I wanted to make on this that are with regard to your computers, your tablets, your documents. In the event that those are taken, do you have backup systems? ICE could have a warrant to confiscate computers. If that happens, do you have things, you know, do you have a document management system saved in the cloud? What would you do in that event so that you don't have to stop operations? So think through, you know, do you have hard copies of documents? Do you have hard copies of electronic documents, and vice versa, so that in the event items like that are confiscated during an enforcement action, you do not have to stop operations. And next slide. One other point as well is be careful with your employees that you are not providing any employee legal advice or anything that could be considered obstruction. If ICE comes, we'll give you this warning, you go out the exit door here, or if ICE comes, you have the right to remain silent, which they do. You have the right to request an attorney. You should not be providing that kind of legal advice to your employees. It could be considered obstructionist. And you also want to make sure that you don't have employees who, on behalf of anybody being arrested or on behalf of their own personal beliefs, to interfere with ICE in any way. There are two implications for that. One, they may be arrested, and two, you could also be held liable for employees who are unreasonably obstructing ICE's operations. So best way to prepare for that is, again, have a plan, have points of contact, talk to your employees about, we will comply, we will cooperate, we will not obstruct, and then be very careful that you're not providing any of your employees legal advice regarding what their legal rights are. You may ask the agent to leave a list of all property taken and the names of all employees arrested. They may or may not comply with that request. They don't have to. You may ask for it, but that's why you have that person assigned to follow them and note in their notes anybody who's been arrested or a list of property taken. And again, like I said, you can video record it. If any of your workers are arrested, you may ask ICE agents where they are being taken so that you can assist the worker's family and lawyer in locating them. And then prepare a detailed written summary of what happened immediately after the search is concluded. So perhaps that person that you've assigned to shadow ICE or to either video record or take notes, part of that person's duties is immediately after ICE leaves that they type up a summary with enough detail that it will be useful to you of what happened, who was arrested, what property was confiscated, how many ICE agents were there, who they talked to, just the what, where, who, when, how of the entire enforcement action. And then contact the worker's emergency contact to notify them of the arrest. You may want to do that. Make sure that you've checked to make sure you do have emergency contact information for your employees so that you can be helpful in that way. Next slide. Your employees do have the right to remain silent. They don't have to answer questions, and they may exercise their right to request an attorney. Again, these are rights that they should be read. I would be very careful as an employer of instructing your employees with regard to their legal rights so that you don't run afoul of being considered an obstructionist during an enforcement action. Next slide. Sometimes federal agents may try to determine employees' immigration status by asking them to stand in groups according to status, and they don't have to move, and they don't have to move to an area that is designated for a particular group. Next slide. And then again, as an employer, you want to make sure that your employees know that we will cooperate with a search warrant. We know our rights with regard to administrative warrants or attempts to enter private areas without warrants, but we're going to provide the information that is requested and when it's requested. And we don't need to volunteer information as employees to be compliant with the warrant. And you would advise both your points of contact as well as your employees that you don't have to prove the case, you don't have to defend the work site. Just be polite and cooperate, and we'll get through this. Because any additional information that's offered verbally by the employer can be used against the employer. So just a word of caution there. Next slide. All right, we're at 4, but I do want to address some of the questions that we have.
Are you able to see them, Kathleen? Are you able to see the questions? Or do
I
you
do,
need-
I see them. Okay, so the first question, oh,
I
do you
think
want
the
to
first question, we will respond to the first question on this in regard to the state,
Okay,
what the state is doing. So you can skip that one and move on to the next one.
how about I'm not sure I follow, so I'll just have you read me the questions.
Oh, okay. Actually, the first question's already responded. So you can just go down the list.
Okay, so Stephen's question's been answered.
No, Stephen's question hasn't been answered yet.
Okay, so, all right. Stephen
Sorry.
asks, will the search warrant specify files they have access to? What if I-9s are kept in a different location? Will the warrant specify digital or physical files? So if it's a regular audit of your I-9s, that's going to show up as a subpoena with a document request. So it's not so much a warrant for access to documents in the case of an audit. In the case of a search warrant, it may just say, access to I-9 forms wherever they are stored. So that would include, whether they're in the HR office or they're offsite or they're electronic or physical. The warrant will usually specify I-9 forms wherever they are stored. And so you would be required to comply with that search warrant. Second question, if a business unlocks the entryway to the facility for individuals, clients, customers when they arrive, is this considered public? Probably not, because it's a locked entryway, which requires someone to approve and then unlock the door. I think that would justify it being a private area. And then we have a landlord-tenant question. Can a landlord allow ICE to enter the premises, including basement and rooms? In order to, I'm not a landlord-tenant lawyer, but I would imagine that because that's the tenant's home, a landlord could not give consent to ICE to enter the tenant's home, but could open the door for ICE if they have a search warrant that requires entry into that place. Yeah, so I think they would need a search warrant to enter the tenant's home, but I can't be entirely sure because I'm not as familiar with landlord tenant, but a tenant also has Fourth Amendment rights against unlawful search and seizure in their home, and I don't think a landlord could waive that. And one point on here as well that I think is worth bringing up, if the ICE enforcement agent has a search warrant and it's for the entire facility, open the doors for them, because if that search warrant allows them to enter the areas, if you do not voluntarily unlock or open the doors for them, they can knock them down and cause damage. And that would be a difficult situation for you to deal with. So just remember, if they do have that access, to allow them entry and unlock the room, the conference room, the files for them, or else they'll do it with force. As a local government entity, can we provide a protocol plan of what to do to staff who work in public areas? I think what you're asking is, if we have publicly accessible employees, can we provide a protocol plan to them? Yes, absolutely. If that's your question, everybody on this call should have a protocol plan and go over it with that person and train that person, even if they have, just a list of instructions sitting on their desk. Yeah, you would want to have that in place for them. Then we have a question, is a local government entity considered different than a business for an ICE search, or do all the same information provide here? That is a great question. And I actually don't know if you would have the same ability to send away an ICE agent as a local government entity that a private entity would have to do if I showed up without a warrant or showed up with an administrative warrant. I would definitely check with your with the AG's office on that so that you can be prepared, because I don't know as a local government entity what you would be required to do if I showed up without a warrant or just an administrative warrant, because the state has to also follow federal law. That's a nuanced question that is better addressed by the Attorney General's office. Is it true there is a monetary incentive for people to report undocumented people? I've heard rumors that some local sheriff's offices or states have put some things out there, but I'm not aware of any monetary incentive that's officially from ICE or the federal government. And then we have a question about whether the status of what's the status of nonprofit organizations? Same rules as for-profit employers? Absolutely, 100%. You're going to have to follow the same rules. All right, well, I don't think we have any other questions. Those were great questions. And I hope this is helpful. Please stay tuned. And if there are developments that are worthy of your time, I'm sure Z and I will be back and offer some more information, and always happy to answer additional questions. And we at Ogletree are prepared to deal with whatever the future may hold for our clients and our businesses in Utah. So please reach out with any further questions or if you need help. Thank you so much.
Thank you so much, Kathleen, for that very in-depth presentation. This is just really valuable information. I've been getting messages and chats on how important this information is. Just a couple of notes to the listeners, attendees. This webinar is recorded. We will be sending out recordings for this webinar to individuals who registered, and also the slide deck will also be available for those who attended this webinar. So thank you again, Kathleen. I'm sure that we'll have you back if things change. Everything is very fluid right now, but this has been just amazing information. Thank you so much again.
Thank you for having me.
Christina, if you could advance to the next slide. And the next slide, please. Oh, just let's go one back. This is Kathleen's information. We will share it out after this webinar. Okay, we'll move on to our next speaker. It's my pleasure to introduce Liliana Balanos and Bailey Rivera-Rimes, who will be sharing with us great resources that the Utah Immigrant Advocacy Coalition and the Center for Economic Opportunity and Belonging and Voices for Utah Children have put together to support immigrant families in Utah. I will turn it now to Liliana and Bailey.
Thank you, Bailey. Hello, everyone. As Z mentioned, my name is Liliana Bolaños, and I am an immigrant family policy analyst at Voices for Utah Children, a children's advocacy organization based in Salt Lake City. And I also represent the Utah Immigrant Advocacy Coalition. We are a diverse network of organizations across the state that work closely with immigrant communities at various levels. Our members bring expertise in policy, direct services, and community engagement, all with the shared goal of making Utah a welcoming and supportive place for all immigrants. Today, I'm excited to share some valuable resources available on our website, which is u-iac.com. If we can go to the next slide. So under the Community Resources tab on our website, you can find this guide. And It provides essential information on legal rights, social services, educational opportunities, and economic resources for immigrants and their families. I see that the link was added in the chat. Thank you. So on the screen, you'll see a screenshot of our legal resources page, which highlights these different categories. We hope that this guide will be a helpful resource for you and your employees. And thank you for your efforts to be prepared and informed during this time. We hope that these resources, among others, can be of use to you. Please feel free to reach out to me at Liliana@utahchildren.org if you have any questions about our website or any resources on there. Now I'll pass the time over to Bailey, who will walk you through another key feature on our website, which is our emergency preparedness page and fillable document.
Thanks, Lily. Was previously stated, I'm Bailey Rivera-Wimes. I work for the Center for Economic Opportunity and Belonging. I'm the senior project manager here. And yeah, the center, in collaboration with the Utah Immigrant Advocacy Coalition, created this family preparedness plan. We hope that you don't ever have to use this. However, it's good to be prepared and know that you have a plan in place to protect not only yourself, but also your family and your assets. So within this plan, there are things such as power of attorney, HIPAA, a checklist for your belongings, your information, your spouse's information, what to do with your utilities, what you're going to do with your bank accounts, your cell phones, and other essential needs such as those. And this is just so that you understand that you have rights and you also have resources and things that you can do in preparation if you or any of your loved ones is detained by ICE. So yeah, I think that's it. Do you want to add anything, Lily?
Nope, that was great.
Oh, and you can access this document and the QR code below, and it's available in Spanish and English. Pass it to Z.
Yeah. Thank you so much, Lily, and so much, Bailey, for sharing those informations. Please, if you have any questions, please type them on the chat, and we'll try to answer them. We do have a question on the chat. Is this something that we can share with employees directly? I'm not an attorney, and I don't know if Kathleen is here, but this is this information resources, and I think that as long as you're providing them that this is just information resources that the community have prepared, I think you should be okay. Is that okay, Kathleen?
Yes.
Are you?
That is, and I actually failed to mention, even though the employer doesn't want to let an employee know what their rights are as an employee, or what they can do and what I would recommend. And this is a great resource. Please refer them to the Utah Immigrant Advocacy Coalition. I can't answer that question. I can't give you legal advice, but here's a resource you should contact. And that's how I would recommend that they handle it. So this is great to dovetail right into this. And that's what I would recommend.
Thank you so much, Kathleen. So yes, please share this resource with your employees. It is a downloadable form, so you could download it and you can type directly into that plan. A couple of things to also mention in the plan too. We recommend that the individuals fill out the plan, make copies of the plan, and make sure that they are stored in safe places and share it with people they can trust. Because the plan is not going to be useful if people are not able to use it to help you in case someone is detained. So this is an important resource. Please go to the Immigrant Advocacy Coalition website. This is going to be a website where we'll continue to share resources. As we mentioned earlier, we are living in very fluid times, and so we will be responding to the various changes in the immigration space, and we'll try to update as much information as possible on this particular website. Liliana and Bailey, did I forget anything else?
I don't think so. That's it. Thank you.
Okay. We're actually ending it early. Is there any additional questions? Anything else that people want us to answer? Pete, do you have any closing remarks? We might be able to just close the webinar early.
I guess I would just share that, as was mentioned by Kathleen, this can feel like a crisis, but being prepared hopefully helps people feel more calm and able to engage, as appropriate and protect people's rights. So I think this information should be very helpful. And thank you to everyone who has participated and shared it. And please let our Center for Global Talent know if there's other types of resources like this that we can help with. And Z, we appreciate all of your team's efforts, and especially Kathleen.
Thank you so much, Pete. We thank you for your partnership as well in making this possible. Just to conclude, a March webinar is scheduled. We don't have a date for it yet, but we will be sending it out. But the topic for the March webinar is a recap on a 2025 legislative session. There are several bills in the legislature that might have affect immigrants in the state or new Americans in the state of Utah, and we'll make sure that we provide you an in-depth overview of those bills. I also want to remind everyone, if you're not a member of the New American Task Force, we encourage you to join the task force. There's a QR code there, just scan it and be able to join the task force. Is free. And as a member of the task force, you will continue to receive resources and information from us. And with that, maybe we'll give back 10 minutes of your time. Again, just reiterate, this webinar is recorded. We will be sending out the slides. Thank you so much, everyone.